Hi, everyone. Thank you for joining Scherini Lawyers on our YouTube series. Today, we've got Sach Fernando, Accredited Specialist in Personal Injury from Maxiom Lawyers. He's the principal lawyer and managing director of that firm. How are you, Sach?
Hi, Michael. I'm doing very well. Thanks for having me.
We like to have more practitioners that are well-rounded and have a very broad knowledge of their area and surrounding areas of law that might also overlap. And that sort of leads me into the conversation we're going to have today, which is when commercial and personal injury litigation overlaps. And we see this occur infrequently. It doesn't happen in every case. If I had a question around personal injury, I may, brief you and ask you a specific question or even introduce a client to you and work together with you on files. And that collaboration really is with the ultimate aim of delivering the best outcome to the client in their best interests. Have have you had any experiences yourself?
Oh, look, absolutely. Insofar as product liability type cases I can send, and also superannuation cases I can send, we have to, especially in the latter, look at contracts and trust deeds and policy documents to ensure that our clients are meeting the policy definition. And sometimes where we do end up litigating is if we can't reach agreement on whether that definition has been established. And often that is dependent on the medical evidence that we obtain as part of the proceedings. Our clients need to establish in superannuation cases where there is contained within the superannuation policy a total permanent disablement and insurance benefit, where our clients need to typically meet the definition that they're unable to perform work that they're qualified, experienced to perform. So there's often disagreement about that, and we defer to the opinion of doctors to satisfy that definition. And then in the end, it becomes a battle between two doctors, a doctor that the insurance funds, the superannuation funds are relying on, and the reports that we are relying on from the treating doctors and other medico legal doctors.
Yeah, and with interpretation of contractual terms and things like that, like policy documents, would you ever, consider perhaps getting advice from someone outside of your area, such as, you think it's a complex matter? It may not be the reference to the example you just made, but it might be something more complex, something that you haven't encountered. Would you engage a commercial litigation or a commercial specialist lawyer or barrister to help you interpret specific clauses because of their experience with contractual interpretation, where your experience is partially that, but also mainly involved in litigation with the personal injury nature?
Michael, the answer is absolutely yes, because we have to stick to what we're good at and what we have specialized in. And in my case, that is personal injury. And so if we're confronted with a situation where there is a contract involved, and we need clarity on how that contractual relationship has an impact on the personal injury claim, I'd be deferring to your expertise in relation to that, and being guided by you in terms of how potentially the personal injury case can impact on the contract. Could it result in a potential contract breach, or potentially even where there's employment law matters involved as well, where clients are required to sign a deed of settlement, to review the deed of settlement to ensure that our clients are not signing away their rights to damages under the workers' compensation, or any other personal injury legislation.
Yeah, and I would also likewise defer to your expertise whenever I need that extra level of expertise for my any personal injury matters, particularly where they're complex or maybe overlapping. And most people think commercial litigation is about money and personal injury is about accidents. But we've got to think about what happens when a business decision or a business product causes real harm to a person. And you've just touched on some examples there. And I think they're highly relevant. For example, if you're conducting a case in a commercial litigation matter, and it might seem like a straightforward contract, you've got an obligation as a lawyer, as a solicitor, to consider broader areas of law that might be relevant. And that's your professional obligation to consider those. And it doesn't mean you necessarily have to be an expert in those areas, but you should be, if you're well experienced and experienced enough to know to be alive to areas that might be relevant, and then reach out to your network and people, and that's where you can make sure that things don't get missed, there's always a cost balance, of course, in obtaining advice. But if you identify something where it might overlap, I always think that it's important to explore that. What do you think?
Oh, you definitely must. And we do defer to the opinion of other lawyers in different specialties from time to time. And one classic example is if our clients are going through a separation, we need to obtain advice sometimes from family lawyers as to how the award of damages can have an impact on the asset pool as part of the divorce proceedings, so as to ensure that everything is done right by the client, but also making sure that what is happening within their personal injury claim doesn't hinder or disadvantage them in their family law proceedings.
These cases are common because the real world isn't really neatly divided, is it? The injury happens to a person, but the responsibility often sits with a business, a contract, and an insurer. And you really got to have some broad knowledge over the areas that touch and overlap, and knowing when it's within your wheelhouse, your expertise, and knowing when to get advice and get help. And that's the points that you made just then, which is highly relevant as well. And so today, we'll cover some relatable crossover scenarios and what claims usually get run, what evidence matters, how these disputes actually move through the system. And the first thing I want to talk about today is thinking about a simple concept: injury and a business overlap. Commercial litigation, effectively, they're business disputes. We're talking contracts, negligence by businesses, insurance, suppliers, directors, and personal injury, on the other hand, is harm to the person, physical, psychological, and really a lot about compensating the person for that. If a business relationship or business activity causes harm, you often get both. You can end up with liability arguments plus injury and damages arguments. And that's when things become very complicated, and it requires, some thought to work through those things to ensure that your client's getting the best representation, the best advice available to them. Wouldn't you agree?
Completely agreed. For example, if a client of ours sustains catastrophic injuries in their workplace, the reality is WorkSafe will prosecute the employer and potentially its directors. And there's a separate proceeding that happens outside of our client's personal injury law claim. WorkSafe, its prosecution arm, will prosecute the employer at the magistrate's court. The matter will be listed before a magistrate where our client's victim impact statement can be read out. By that time, WorkSafe's investigation team would have prepared a brief to the prosecutor containing a number of documents with respect to negligence, liability. Often it's around the machinery that was involved in the injury that our client sustained. And the courts in those sorts of cases can impose fines and convictions as against the employers directly. Now, we would lean on the brief, the prosecution brief, the sentencing, the judgments, the rulings in those proceedings to strengthen our case against the employer in order to maximize the damages, the common law damages that our clients are entitled to. So from the prosecution brief, the improvement notices that have been issued, from the pure fact that there's been a sentencing and conviction of the employer, that really strengthens our case in negligence as against the employer. And then the fight in the personal injury law claim turns to quantum and assessment of damages. And of course, we'll still be met with arguments around contributory negligence, and that the damages should be reduced by 20% because our client didn't follow appropriate protocols, etc. But you can run the trial knowing that you will ultimately prove negligence because of the success of the prosecution.
Yeah, that's great. And that's, overlapping as well with potential civil penalties or criminal offences as well. And that's also highly relevant as well. And then civil liability, can stem from those, and they may run first. It's quite common for criminal matters to often run first, and then for the civil to come after and piggyback and tack on after. So that's certainly a common thing that occurs. Common ones we get is you're injured by a product you bought, injured at a shopping centre or a business premise, workplace incident, but with multiple contractors involved, psychological harm from a workplace process gone wrong, professional advice leads to financial loss and mental harm, which can happen. So there's definitely examples, and you might have examples, especially with particular professional advisors, where you might have concurrent contractual and common law rights, such as you might have a personal injury that stemmed from the advice that was negligent, but you might also have a breach of contract for failing to fulfill a retainer or certain contractual conditions. So you can certainly see how the overlap can occur. Sometimes the cases can be run together in the one proceeding, and depending on whether or not there's jurisdictional issues or restrictions, you may have to run them separate. One example is, for example, we had a recent case where a client had engaged an accounting firm and sought advice. The retainer was clearly scoped. Now they failed to perform the scope of that retainer, but also the client, through that experience, sustained a psychological injury and then ultimately pursued that. And ultimately the claims were all brought together in the same proceeding in the Supreme Court of Victoria. And it was quite serious, and it went on for a long period of time. And so, there's obviously, as you would be able to comment on, that there might be threshold issues under the Wrongs Act around psychological injuries and then the kinds of damages you can claim. So they're not all worthwhile running, but certainly there is a possibility to run those sorts of claims where they overlap. What do you think?
Look, definitely. They'd be, in my experience, and I must say, Michael, I've got very limited experience in that particular scenario. Today I had an interesting case where we had lodged a serious injury application on behalf of one of our clients, and it was an aged care facility who was the employer. The Victorian WorkCover Authority indemnifies the employer and are responsible for the determination of whether or not to grant our client a serious injury certificate. But what happened during the assessment process is that the lawyers acting for the authority found that the aged care facility was owned by a separate entity who, under the aged care legislation, the federal legislation, has a responsibility to ensure the safety of the staff and occupants within that premises, despite not having any control over the system of work which the employer dictated. And therefore, our argument is, well, as the employer, you've got a non-delegable duty to ensure the safety of your employee, our client. The employer's argument against the proposed second defendant is that under the aged care legislation, the occupier has a non-delegable duty to ensure the safety of its staff and its occupants, irrespective of not having any control over the system of work. So what will happen in that scenario is, if we can't reach settlement, and it would be very unfortunate if we couldn't reach settlement because it's a modest claim, we'd need to run the proceeding at the county court. And we'd need to have the liability fights and fights around breach of contract in the same hearing. And it is incredibly frustrating to the injured individual, because until the two defendants work out contribution and the issues around liability, they can't make any meaningful offers to settle the case. And so we would potentially be forced into a litigation and go through the costs and the costs and the delays associated, purely because there is a contractual issue that the two defendants cannot agree on.
That's a fantastic example, Sash, and a great example of an area of the justice system that probably needs reform and improvement. The old saying, justice delayed is justice denied. And quite often it's not necessarily the court's fault at all. It's the system that the courts are required to work within, the framework, the legislative framework. And so there's really not much they can do. It's sort of a matter sometimes for lobbying Parliament effectively to bring about change. And I certainly can sympathise with you there, because we've been in similar situations where two parties to a proceeding are having their own little stoush, effectively, which really holds up progress for the person who's aggrieved, who's brought the proceeding. So certainly an issue. Really great example to highlight, by the way, Sash.
We had a case which resolved late last year, and that case went all the way to a mediation, and we were a month or two prior to trial, despite our client having quite serious injuries. Now, our client steps on a crack and loses his footing and suffers quite a nasty ankle injury. He was employed by Qantas, but the incident occurs at Melbourne Airport where he's working. Now, the argument was that where the crack was, that side was owned by the airport. Had it been on the other side, it would have been the responsibility, contractually, it would have been the responsibility of Qantas. Both sides were pointing blame at each other. And they just could not get clarity on which side and the parameters of the area that each of them were responsible for. And so we end up going through the whole litigation process, discovery, interrogatories, engaging experts to provide opinions on the system of work. A lot of time and expense exerted into this case, and ultimately it resolves before we get to trial shortly after the mediation. But that is a perfect example of a case that went on unnecessarily for too long because the two defendants could not agree on whose responsibility it was based on their contract. The employer in this instance has a non-delegable duty to ensure that wherever its employees are working is a safe environment. And so the criticism of the employer is, well, you should have noticed this crack. You should have talked to the airport and made sure that that area was remedied, was covered up, so that the Qantas employees wouldn't trip and fall.
Yeah.
Whereas the airport was saying, well, this falls on your side of the line, and therefore you're responsible for attending to its repair.
Yeah, and that's the difficult part, is when it's the he said, she said, finger pointing, which thwarts the progress of proceedings. Now, I want to turn to some, if you don't mind, just a few overlap scenarios. Some people watching might be able to identify with any of these examples, or might have been experienced that either from a professional position acting as a lawyer or an advisor, or perhaps as a client, or just a lay person in the situation, unfortunate situation. But the first one that appears quite commonly is defective products. You've got consumer and business accountability. If a product injures someone, what's the legal pathway in plain terms? So, often it can be framed under the Australian consumer law, consumer guarantees, safety representations, plus negligence. Can become multi-claimant, group-style disputes if the product is widespread. And the kind of evidence that you might need is, product IDs, batch serial numbers, purchase proof, medical links, recall notices, if any. This is the common one that arises.
Correct. And it would still be, again, the same proceedings, but you'd have multiple defendants involved because of the contractual relationships between each of the entities. For instance, right now we have a case where our client bid into a pistachio and, bought a pistachio product from a grocery store. And unfortunately, there was a piece of stone that was within the bag, and she's bit into it and has suffered some serious injuries. Now, in that instance, we are pursuing the claim under both the consumer law as well as the Wrongs Act legislation. We are suing both the manufacturer of the product as well as the company, the grocery store that was selling that product.
And that would seem to me to be most appropriate path. So I'm sure that the client's in very good hands there. And the second example I'd like to highlight is injuries on business premises. Very common to you, Sash, you know all about it. Slips, trips, falling on objects, the classic, I slipped at the supermarket. What actually matters legally? From my perspective, and I'll let you comment, but from my perspective, it's you got issues around reasonable safety systems, inspection, cleaning, warnings, and these claims are usually run against the occupier of the business and handled through public liability insurance. And evidence that I see that's important is often incident reports, CCTV photos, witness details, medical records, and I'm sure you've had more than a couple of those in your time, Sash.
I certainly have in the last 16 years, Michael. One recent one involved a client of ours who was walking from her parked car to the place of employment. She was working at this particular premises, but her employer was actually a labour hire company. And so she has a trip and fall on this the residents of the commercial premises of where she worked at, and so she ends up suffering a nasty elbow injury. And when it came to her common law claim, we had to name her employer, the labour hire company, the occupier where she worked at. We had to name the entity that owned the building premises, the commercial premises. And unfortunately, there were a number of entities involved, including who that big premises was leased from. So we needed to name the landlord and whoever was on title, because whose responsibility was it to maintain that crack where our client slipped and fell? The employer had this non-delegable duty. It's the occupier where she worked at. It's their premises that she's required to attend. So what responsibility did they have even in notifying their landlord that there was this crack that their workers could potentially trip and fall? And then from that landlord, which entity did they lease from? So it was very complex, and it again a case where we had to issue proceedings.
And that segues into the next point. Work sites and third-party workplace injuries. We know WorkCover exists. So when does it spill into broader litigation where multiple entities are involved? Principal, contractor, subcontractor, site controller, equipment supplier, site owner, lessee, lessor. Often you see one injury, several businesses, big insurance contribution disputes. We've touched on this, and it really highly relevant to the case that you just gave us some information about.
It's right on point, isn't it, Michael? Unfortunately, I don't think it increases the injured individual's entitlement to damages, but we plaintiff lawyers, do like it when there are multiple defendants, because typically, if everyone does cooperate, we can potentially extract a bit more for our clients. And the cost thresholds that are typically applicable in workers' compensation damages trials, not so relevant when there are multiple defendants.
Yeah, and that's all part of the case strategy, and that comes from experience, Sash, your 16 years of excellent experience that you're bringing to the community and the people of Australia. And now I want to turn to the next thing, which is professional negligence with human impact. We touched on this earlier. I gave an example about an accountant. People think professional negligence is just financial, but it can be deeply personal. Bad advice or process can trigger intense stress, psychiatric injury, or family consequences. Damages analysis become more complex. Financial loss plus health impacts and treatment. It's definitely not without its concerns. For example, providing professional services or services generally, that you can actually you can injure someone, and it's not purely always about money. There sometimes can be a personal injury involved.
I must say, Michael, I've had very limited experience in professional negligence claims. The one claim that I did pursue involved a lawyer missing a certain deadline to issue an originating motion at the county court. Now, even in that respect, to succeed in a professional negligence case, the injured worker in that instance will still need to establish that there was a loss caused by the negligence. And in this instance, the fact that the lawyer he had engaged missed the deadline meant he couldn't issue the proceedings on time. The reality was he would have succeeded in the proceedings because he would have proven that he suffered a serious injury and that the serious injury happened due to the negligence of his employer. But to succeed, there needs to be you still need to demonstrate that the negligence resulted in some loss and damage. The negligence of the professional service provider, in this case the lawyer, resulted in loss and damage.
And we call that, we refer to that as causation, which is a bit of legal mumbo jumbo, but there has to be a causative link there.
Exactly. It's fine. It's well and good that this person was negligent, and often people are very quick to point to the negligence, but what loss and damage has been caused by that person's negligence? In this case, it was a significant loss because it's a loss of opportunity to issue proceedings and be awarded common law damages. Now, we still had to establish on our client's behalf, or our client had to establish, that he sustained serious consequences of the injury, and that those injuries could have been avoided had it not been for the negligence of his employer. And so we still had to adduce medical evidence to substantiate the severity of our client's injury.
Yeah, they're basically running parallel, the negligence claim against the solicitor and then the underlying claim that was ultimately missed by their negligence. So that's very interesting. And the final example that I've also could think of is employment processes causing psychological harm. Think about performance management, investigations, termination processes. You've got to ask yourself, where's the legal risk line as an employer? And this applies to anyone, any business. Poorly handled processes create overlapping risk employment claims, injury style, compensation pathways. The key theme that we see is process discipline, fairness, documentation, tone, supporting, timing, document record keeping being imperative. And that's often something that we see happening as well in terms of crossover between other types of civil litigation and personal injury.
As an employer, now, of course, I only act for employees, but I am an employer. And you have to be very, very cautious and careful in the way you manage someone's performance. I've seen countless times in my career clients developing psychological issues due to poor management of performance by their employers. Now, an employee is entitled to investigate your performance. And ultimately, the question is whether that investigation is done reasonably, whether the management action taken by the employer is reasonable management action taken on reasonable grounds and in a reasonable manner. And if the answer is yes to any of those, and your condition wholly or predominantly is sustained, the psychiatric injury is wholly or predominantly sustained by the management action that's been taken reasonably, then unfortunately there is no entitlement to compensation. There's a specific exclusion under Section 40 of the Work Act, which disentitles people to compensation in circumstances where their mental injury has come about in that way. It's awful because, well, no one wants their performance to be investigated, and it's a horrible thing to go through. But you are not entitled to compensation because you're upset at the process of the investigation and the management action.
And, you can also see it from a different perspective as well. We often see that Section 40 being misused by insurers to simply reject claims broadly where they're legitimate claims as well, don't we, Sash?
Oh, we certainly do. Section 40 cases are very difficult to defend. I mean, they're difficult for the injured worker as well, but they're particularly difficult for employers to defend. Often people do the right thing by their employers, and employers need a very good reason to investigate an employee's conduct. Where we see the defence falling short is in circumstances where they've not followed due process, or during performance management meetings, the managers involved are not being professional. The employee is not being provided notification of the performance issues. They're randomly called into a meeting, and say, the manager comes and says, "Hey, Mike, need to have a chat, come in." They go in, all of a sudden performance issues are being raised, they're being yelled at, they're being screamed at, and the employee is just in shock at what's happening. Even if there is a legitimate basis for calling this interview with the employee, there is a way in which that interview should be conducted. And they denied procedural fairness. So that denial of respect, professionalism, procedural fairness enables us to then argue that this process was not reasonable management action.
Yeah. And, it's a great example. And I often turn to think as well, what claims, what issues usually get run in the circumstances of the crossover of litigation, commercial, other civil with personal injury. And without getting technical here, what are the legal levers you actually pull? And the common ones that I think of are statutory consumer claims, ACL issues where product services cause harm. Then you've got negligence, duty breach, causation, loss is the usual framework. Contract-related issues, what was promised, what warning terms existed, who owed what. Then you've got insurance coverage fights, who pays, which policy responds, exclusions, notice issues, other statutory issues relating to insurance and coverage. And then you've got other things like multi-party liability, which we've discussed at length, where everyone points at everyone. And then you've got issues around contribution or apportionment, which are two different legal principles. So, yeah, it's not necessarily either commercial or injury. It's often, running both in parallel. And we've touched on that earlier, that they can often run parallel, and sometimes they can start as a personal injury claim and morph into a commercial or a parallel claim, or it could start as a commercial claim and morph into a personal injury claim, or they might split out. They might be run in different jurisdictions for different reasons. And so it's really a matter of keep continuing to review the case as it progresses, as evidence comes to light, as discovery or disclosure occurs, further instructions from your client, documents come to life, other witnesses come to life. And by that, it really helps you, assess the case on an ongoing basis, because you really want to do the best you can for your client's interest, don't you?
Exactly. And often through discovery, we're able to identify any other prospective defendants that are involved. Of course, we want to make sure that the proceedings are issued against everyone responsible for our client's injuries. And so from that point of view, it's important to, in terms of maximizing our client's benefits and entitlement to damages, that all people responsible for their injuries are included in the proceedings.
Yep. Identifying the right defendants and identifying all the defendants, whether it's possible at the beginning or if it comes out with time, as you say, through the procedures of the court or the jurisdiction you're in, that you join those parties as it becomes evident that they are probably liable or to some degree in the matter. So I totally concur with that. I think that's a very important point. Identification, constant review of who are the parties to the proceeding, and also removing parties, not just joining, but removing them where they're not appropriate party to the proceedings. Remove them early, avoid the cost risks.
Also, Michael, under the Civil Procedure Act, we all have an obligation to make sure that if you are suing someone, there is a proper basis in doing so. There is no point in pursuing a case against a prospective defendant if there is no proper basis, and it's in contravention of the Civil Procedure Act to do so.
I agree, and the overarching obligations really direct lawyers, solicitors, barristers to take the right steps and to act with integrity and ethics. That's effectively the spirit of the Civil Procedure Act at its heart. So if it becomes evident that a party shouldn't be there, you should be giving your advice to the client that that they should be removed, or if they're asking to be removed, that they be permitted. And that's really the best advice you can give. So it's an important point, and quite often something that's overlooked, and then you end up with a whole bunch of cost fights at the end of the matter, which could have been avoided had you taken the action earlier.
Well, exactly. The other risk to your client is that they serve a Calder bank on you, and then the case goes pear-shaped, and there's cost consequences on your client.
Correct. And that's just another element in it, a Calder bank or even an offer made pursuant to the court rules, or both. Quite often we make both at the same time to cover all bases. Obviously, we know costs are discretionary, but you might have some levers under the rules that require the court to increase the cost by a certain percentage. So not often that you see parties in those sorts of multi-party disputes not serving offers at some point in the proceeding, and sometimes it's from the beginning if it's plainly obviously hopeless, or if it requires discovery, then at that point mediation generally offers will be made formally, and that's often an appropriate time to do it. And that puts everyone on notice and on risk that they really need to assess their case closely. And that sort of, obviously, as you say, brings people to the table. So, but one thing that I can say is that if there's one point that I've learnt over my time working as a lawyer, it's delays kill claims. Evidence disappears, CCTV overwrites, witnesses forget, they can't be located. Delays kill claims. Always act swiftly and talk to your lawyer. Try and preserve evidence, and that will at least give you the opportunity to then think about whether or not you want to bring an action, but you've actually organised and preserved the evidence and the documents you need, or made the inquiries with third parties where you need to.
Exactly. I couldn't agree with you more, Michael. And I suppose as practitioners, working collaboratively to try to resolve the matter early, sooner rather than later, to avoid costs and delays, and to avoid clogging up our court system. Pick up the phone to your opponent early on. Make sure even before issuing proceedings, you do your due diligence to ascertain as much evidence as you can. Because I think if you can present a case that carries sufficient risk to your opponent, at least in our jurisdiction, early on, litigation could probably be avoided.
Yeah, and look, I'd love to just wrap up today. It's been fantastic. We think these disputes are connected because business activity affects people. If you're dealing with harm, evidence, and insurance, you want someone who can join the dots, like yourself, Sash, or myself, where we can have that sort of broader perspective on the case. And the earlier you get advice, as you say, the more options you have, and the less likely it is you'll spend months chasing the wrong pathway or losing precious evidence and information that could have been collated when the matter was fresh in your mind. Even if it's just considered to a contemporaneous interview with your lawyer, record it and come back to it later on. It's always a good idea. It gives you options. And quite often people will come back after a period of time and they realize that the scar on their arm that they got from the boiled drink that fell on them at the cafe, the scar hasn't gone away, and it keeps reminding them of that incident. And it's, it's ugly, and they're unhappy, and they want to bring a claim, but because they didn't act swiftly, they're out of time, or they don't have the evidence now, or the CCTV or the camera in the cafe is gone, because you need to get your lawyer to write to them and ask them to put them on notice to preserve evidence and so forth, and these standard procedures that we undertake. So really important that people understand that taking swift action and talking to the right people, don't just talk to any solicitor or any person out there, but really think carefully about who you're engaging. Is it someone like Sach Fernando, who's, excellent in your area, or is it, Scherini Lawyers, where we service people and we have a very broad perspective on the way we approach cases due to our background in a variety of different areas of law? Think about it carefully, make the decision carefully.
That's a really good point, Michael, because often people don't know that lawyers do specialize, and there are accredited specialists. Of course, as lawyers, we all know that there are certain specialists, but I think especially if you're injured, people think they can just go to a generalist lawyer, or their uncle who practices in family law to get some direction. No, you need a specialist injury lawyer for an injury claim. You need a specialist commercial lawyer for a commercial matter. And that's where you get the best advice. I really pride myself in what I do. I love what I do. I love helping people. I think it's a real privilege for me to be doing what I do for the most vulnerable members of the community. And we're very passionate about what we do, because at the end of the day, people engage us during one of the most difficult times in their lives. And we have, as their lawyers, that responsibility to make sure there is no stone unturned, to make sure that our clients get the compensation, or for them, the justice that they deserve.
Yeah, we're very lucky to have yourself, Sash, and your firm, Maxiom Lawyers, in our industry, and more lawyers like yourself in your firm, the industry would be much better and would always be improving. So hopefully, you can pass your knowledge on, as I'm sure you do, to your staff and your junior lawyers. And I hope that this video has really helped people who are interested in this topic and want to learn more about your firm, or you or me or my firm, or just interested in the topics, whether you're a law student out there or whether you're a experienced King's Counsel or a judge watching. We hope that you enjoyed the video, and really thank you for coming on today, Sash, and giving your time. And I look forward to having you on in the future. I would love to have you back if you would be willing to do so.
I'd love to, Michael. Thank you so much for having me on the program, and congratulations on all your success at Scherini Lawyers. And equally, the profession is very lucky to have you. All the best.
Thank you so much. Thank you, Sash.
Thanks, Michael. Take care.